Hi, my name's Charlotte and I'm studying for a PhD in socio-legal studies. My research combines law and social science, and I did my undergraduate and my master's in law. This is a statute book for criminal law, and every first-year law student will own one of these. It contains the most important criminal laws. The writing is small, the paper tears easily, it doesn't look too exciting, but I can assure you that it's very useful for propping open a door. However, the laws within this book, passed by Parliament and setting out exactly what conduct is criminal in England and Wales, are vital, essential to daily life, and likely affect your lives, even if you're under 16 or 18, in ways you may not imagine. In this video we have 3 objectives. Firstly, to understand how a law is written. Secondly, to look in more detail at the criminal law about sexual touching and apply it to factual scenarios. And thirdly, to compare how different countries legislate about sexual touching between young people under 16. So, today we will be looking at the Sexual Offences Act, which is a statute which was passed in 2003. A statute is a written law passed by Parliament. Anything called the Something Act, as lawyers we might call statute. This statute covers a range of sexual offences, such as rape, but we're going to be looking at crimes to do with sexual touching, often called sexual assault. So, here is the section of the statute which defines sexual assault. Section 3, Sexual Assault. Subsection 1. A person, A, commits an offence of sexual assault if, paragraph A, he intentionally touches another person, B, paragraph B, the touching is sexual, paragraph C, B does not consent to the touching. As statute is written in a formal way, which may be new to you, you need to know a few things so that you can comfortably read and understand it. Statutes are divided up into numbered sections. You can probably guess that this is section 3. Essentially, it's a subheading. Statutes can contain hundreds of sections, so knowing the section that we're looking at is important. Each section is divided into subsections, and then subsections may be divided into paragraphs, which are divided into subparagraphs. Don't worry too much about the terminology here. The important thing is that by splitting up the section, it makes it easier to navigate than just looking at a block of text. A key skill of a lawyer is to be able to carefully examine a section and its subsections to work out what the law is. Don't bring any assumptions in. This isn't what the law must be or what sounds fair. We're interested just in the words on the page. Note that this offence is only committed if all 3 of paragraphs A, B and C have happened. Something which is very common in law students when they start is to look at a section, spot one thing is true, and therefore decide that the crime has been committed. In this case, because there are commas and the word or is not included, we know that this is a list, and all 3 of A, B and C must be true for the offence of sexual assault to have occurred. You may well be wondering, what counts as sexual touching? No more detail is given in the Act, but there have been a number of cases in court where judges have decided what counts as sexual touching. And, in a case last year, it was decided that sexual kissing on the lips, was a form of sexual touching. Here's a second section, also from the Sexual Offences Act. There is a third section which deals with sexual activity where a child is under 13, which imposes higher penalties because of concerns that children under 13 are particularly vulnerable, but we're not looking at that here. Bear in mind, though, that when we're talking about the victim being under 16, we're mainly thinking of a victim who is between the age of 13 and under 16. Section 9. Sexual activity with a child. Subsection 1. A person, A, commits an offence if, paragraph A, he intentionally touches another person, B. Paragraph B, the touching is sexual. And, subparagraph 1, that's the little Roman numeral 1, B is under 16. What do you notice is different between these two sections? Well, first of all, obviously there's a difference in victim. In section 9, the victim is under 16. Is that all? Crucially, look at the requirement for consent. Consent is simply agreeing that someone can do something. I can give consent for someone to borrow my computer, and I can give consent for someone to touch me in a certain way. Consent is mentioned in section 3, but not in section 9. And this is really important. Paying attention just to the two sections of statute on this slide, and the words as written, try to write 2 sentences which you could use to explain the law to a friend. First of all, just look at section 3, which doesn't talk about age. Start your sentence, it is illegal to. Now look at section 9. Start that sentence, if the person being sexually touched is under 16, then it is illegal to. Pause the video while you write. One version would be, it is illegal deliberately to touch someone in a sexual way if the person being touched doesn't agree to be touched. If the person being touched is under 16, then it is illegal to touch them in a sexual way. It is illegal even if the person under 16 agrees to be touched. Just a note, because we only have limited time, I've edited these statutes to combine section 9 and another section, section 13, into something easier to discuss. But in the extension materials, I've included the full unaltered text of the relevant sections from the statute, with some explanation. Scenarios are stories which people teaching and researching law make up to see what would happen in a certain circumstance. We want to understand what effect this law, written on paper, would have on real people's lives. Let's start with the story of Alan and Betty, who work together and are both aged 20. One day, unexpectedly, Alan kisses Betty on the lips and says he has fancied her for months. Betty is horrified and says that she never gave Alan permission to touch her in that way. We're going to look at section 3 to see if the crime of sexual assault has occurred. Remember, we need A, B and C to be fulfilled for the crime to have happened. So, A. Alan, has he touched a person? Yes, a kiss is obviously a touch. Was it intentional? Yes, he didn't slip. It's clear he kissed Betty, intending to kiss her. So, B. Was the touching sexual? Yes, as I mentioned earlier, the courts have decided that a romantic kiss is sexual touching. And C. Is it true that Betty did not consent to the touching? Yes, that's quite obvious here. Betty never agreed with Alan that he could kiss her. So if we look at the crime of sexual assault under section 3, sexual assault has happened here. Here's your task. Look at the 2 scenarios on the next slide and decide whether sexual assault or sexual activity with a child has occurred in either scenario. In order to decide whether either or both offences have happened in these 2 scenarios, you'll need to look again at Section 3 and Section 9 of the Sexual Offences Act. For ease, they are available as a download. Here are your two scenarios. Let's work through these scenarios, just like we did for the first scenario. Remember, we need to look at both Section 3 and or Section 9 to discover whether an offence has taken place. Carlotta, who is 15, kisses on the mouth Davina, who is also 15. The two girls are girlfriends, but Davina has said that she isn't ready for kissing or touching yet. Looking at Section 3. First, A. Has Carlotta touched Davina? Yes, clearly by kissing her. B. Was the touching sexual? As you'll remember from our first case, kissing is considered sexual touching. So we look at C. Has there been consent? The question here, really, is has Davina agreed to be kissed? No, she's made it clear that she doesn't agree to be kissed by Carlotta. So all the elements of Section 3 are made out. So we know that a crime has been committed under Section 3. But let's just look at whether a crime has also been committed under Section 9. If we look at subsections A and B, they're the same for both Section 3 and Section 9. So we already know that intentional sexual touching has taken place. But look at paragraph B, subparagraph 1. Davina is under 16. So all the elements of Section 9 are fulfilled as well. Carlotta could be prosecuted either under Section 3 for sexual assault or under Section 9 for sexual activity with a child. Emmanuel, who is 14, is the long-term boyfriend of Felicia, who is 15. One night, they're watching a romantic movie. Emmanuel says, "I love you." Felicia says, "I love you too," and Emmanuel kisses Felicia. Look at Section 3. Once again, A and B have happened. The kiss was an intentional sexual touch. But what about C? The situation here is different to that between Carlotta and Davina. Felicia's behaviour here makes it clear that she does agree to the kiss, so she is consenting. Therefore C has not occurred. There was consent. Remember, we need A, B and C to be true for the offence to be committed. So there is no offence under Section 3. But what about under Section 9? Once again, A and B have happened. The kiss was an intentional sexual touch. Think back, though, to the sentences you wrote which explain the difference between Section 3 and Section 9. Felicia is 15 and therefore under 16. For the crime of sexual activity with a child to occur, all we need is that there's the intentional sexual touch of someone who is under 16. It doesn't matter that Felicia consents and was very happy to kiss Emmanuel. All elements of the offence of sexual activity with a child have occurred. Emmanuel could be prosecuted. Does the last one surprise you? Does it match up with your own experience of life? A very senior judge called Lady Hale said, "The message of Section 9 is that any sort of sexual activity with a child under 16 is an offence. There are a good many policy reasons for the law to convey that message, not only to adults, but also to the children themselves." When the Sexual Offences Act was being debated in the House of Commons, there was concern amongst MPs about what would happen in a situation like that between Emmanuel and Felicia. What would happen if after the kiss, Felicia had kissed Emmanuel? They would both be wrongdoers and victims. Was it fair that Emmanuel would be treated as having committed a sexual offence, even though he is a child too, and actually younger than Felicia? The minister introducing the Act said, "The creation of such broad-ranging offences raises a number of difficulties. There are no convictions at present for kissing. The guidelines for the police and the service which decides whether to charge people with offences will be strong, and I do not think that there will be prosecutions in the future for less serious consensual activity between children." So, on the one hand, judges and politicians feel that there is a need to protect people under 16 from sexual activity. Yet they also recognise that it's not fair to criminalise relationships between people who are nearly 16, where those relationships are consensual and the sexual activity is minor. So one solution is to have the law written down as statute, but to choose not to prosecute in some circumstances. I think in our circumstances it is exceptionally unlikely that Emmanuel would be prosecuted. But this does leave people uncertain. How are 15-year-olds supposed to know whether they will be prosecuted or not? It gives a lot of discretion to the prosecutors. Another of the ways the law seeks to get around the problem of unfairness is by differences in sentences. A person under 18 who sexually touches someone under 16 can receive a lower maximum sentence, 5 years, than a person aged 18 or over who sexually touches someone under 16. Other countries have responded to this problem using different statute. In the state of Tasmania in Australia, for instance, there is something called a Romeo and Juliet clause, after the two young lovers from Shakespeare. This focuses on the age gap between the victim and the person who sexually touches them. If the person being touched was 12 or over, but under 15, then there is a defence if the person who touched them was not more than 3 years older than them. So, if our case with Felicia and Emmanuel had happened in Tasmania, a crime would not have occurred. Why do you think that there is this difference between the law of England and the law in this part of Australia? In Italy, a child is considered to be someone under 14, rather than the English definition of 16. So, in Italy, a person of any age could kiss a 14-year-old with their consent, and there would be no crime. So, here we have 3 points of summary for this video. Firstly, law which might look obscure or irrelevant can actually have a significant impact on teenagers' lives, including the most personal elements. Secondly, one of the key skills of a law student is to think about how a law will apply in different scenarios. This helps us realise if the result of the law might be unexpected. Thirdly, there are reasons for and against setting age limits which make it illegal to engage in sexual activity below a certain age. Different societies and countries will take different approaches. It's up to you to decide which arguments you find most persuasive. Which leads us on to what's next. It's time to try to write your own criminal statute about sexual activity with a child. Do you think that the current law about sexual activity with a child works? If not, how would you rewrite it? Maybe you're convinced by a Tasmanian-style system. Maybe you think that the emphasis should be on whether the victim consents, rather than the age of the victim. As you're writing your own law, think about what you're trying to achieve with that law. As a law student, you'll do far more than just read and memorise dusty laws. Whether you're coming for an interview here at Oxford, a graduate student like me, or a senior professor, we're all engaged in applying the law to real scenarios and then critiquing the law, thinking about what we want the law to achieve and how best to phrase that.